and mandate for immigration matters specifically. There is a lot to this kind of particular type of litigation. It can be a little bit more complicated than it seems. We have a lot to cover, but also I think we're going to have a good amount of time to go through some Q&A at the end if anybody has questions. Um, but I suppose with that, I'll let Simon give his little intro of himself first. I'll do mine, and then we'll jump right in.
Hey, great to meet everyone. I'm Simon Sandoval Moschenberg. I'm a partner at Murray Osorio PLLC. We have offices in Virginia, Maryland, and Newark, New Jersey. And I head up our litigation practice at the firm, and I'm also on the AILA Benefits Litigation Committee and the AILA Federal Court Steering Group.
And I am Zachary New. I'm a partner at Joseph and Hall in Denver, Colorado. I head our employment-based immigration practice, so doing kind of the affirmative visas and non-immigrant immigrant applications for businesses and investors, and then also the litigation that's kind of tied to those specific matters. And then I'm also on the American Immigration Lawyers Association's Benefit Litigation Committee, as well as the Federal Court Steering Committee. So happy to kind of meet everybody and chat through this, really kind of important topic right now. I think this is going to be a bigger and bigger thing over the next 4 years. So we're certainly going to be needing the help. Yeah, I suppose with that, I'll let Simon start us off here.
Okay, so first I want to talk about which types of cases can be subject to a mandamus. And I'm going to use the word mandamus as shorthand for essentially delay litigation generally, whether it's under the Mandamus Act, whether it's under the Administrative Procedure Act. I'm just going to say mandamus as a shorthand. Some of the most common types of mandamus cases are affirmative asylum, right? Whether it's has not yet been interviewed or whether it's been interviewed and is awaiting a decision for an extraordinarily long time. Visa petitions, right? Your I-130, your I-360, an I-730 for derivative asylum status. Adjustment of status, which can often be together with a visa petition if it's a one-step, like a marriage-based I-130, I-45. Let's talk about the U visa for a second. As you know, the U visa has a statutory cap. It's on a waiting list, right? It's by some estimates as much as 17 years. You cannot, a statutory cap is a statutory cap, right? There's nothing you can do in litigation to try to get someone a final adjudication of their U visa if their number isn't up. That's all there is to it. However, if they're waiting for what's called a bona fide determination, that's been unreasonably delayed, you can certainly do a mandamus seeking the bona fide determination, for example. And then naturalization, if you filed a naturalization and they haven't scheduled an interview for an inordinarily long time, that's the type of thing that you can mandamus. There's certain things that you can't file a mandamus over because federal courts have found that they lack jurisdiction over these. The biggest one is waivers, right? An I-601A waiver, unlawful presence, the I-212 for a prior removal order. Also, things like humanitarian parole and military parole in place. These are things that don't even exist in the statute. They're created solely as an act of administrative discretion to begin with. And then, as I mentioned, not yet current priority date, right? For example, if you're in a preference category, or there's some backlog, like the annual cap on special immigrant juvenile approvals, you certainly can't mandamus to get out of the waiting list. You can mandamus the State Department. It's not just USCIS. You can mandamus for an interview if it's taken the National Visa Center an inordinately long time to schedule that interview, or if after the interview the case is placed into administrative processing by means of what's called a 221G refusal to issue the visa, you can mandamus that as well. The State Department mandamuses have a lot of extra considerations, and there's a lot of extra legal issues that aren't present in the USCIS mandamuses. And then there's this one other rare beast called a 1447B case, in which once the naturalization interview has taken place, they have a hard statutory deadline of 120 days. They have to adjudicate the Nats within 120 days of that examination. We don't see a lot of those these days. We only see those in complicated cases because the administration's been pretty decent about getting post-interview nets under control and obeying that statute. But I think it's reasonable to anticipate that over the next 4 years, we're going to see a huge number of these types of cases as delays balloon. We can go to the next slide now. What do you want to do prior to filing a mandamus? This is federal court litigation, and you never want to just rush into federal court without, first of all, analyzing it, very carefully with your client, and then, second of all, taking reasonable steps prior to filing federal litigation. So, the first question you really need to ask is, why does this particular client need a prompt adjudication? Zachary's going to go into the legal test, but suffice it to say that it requires more than just counting the number of days elapsed on your fingers. You have to gather facts for why this particular person is being injured by the lack of an adjudication. And I'm under a lot of stress. I don't know whether my application is going to be approved a lot or not. And all of this delay is delaying my ultimate, naturalization as a US citizen. Those are not good reasons, or certainly not good enough reasons, because literally every single person can say that. You want client specific facts, right? So, and remember, if we're talking about, for example, a pending asylum application, person's allowed to be here. They're not accumulating unlawful presence. They've got a work permit. They're allowed to work, right? So what is the harm of their pending affirmative asylum being delayed? Well, some of these folks actually don't have EADs, right? If you're talking about someone who's waiting for their U bona fide determination, they probably don't have an EAD right now. If you're talking about someone who's waiting for an I-730 to be approved and they're inside the United States, they could even be removable unless and until that I-730 gets approved. But even, for example, for someone with an EAD, I've had tons of clients tell me, well, I get turned down for jobs all the time when they see that my work permit only has another 12 months left on it. And I tell them, don't worry, I'm going to be able to renew it, but they don't hire me, right? Or I can't get I'm in IT. I'm in Washington, D.C. metro area. All the good IT jobs are with federal contractors. I can't get a security clearance with a pending asylum application, or can't get a mortgage. I can't get a small business association loan. A big one we see a lot is my children, who are also derivatives on the application, can't pay. They're being charged out of state tuition. I can't get Stafford loans. I can't do FAFSA for them until they're granted asylum. And then, of course, the strongest cases tend to be for derivatives in the home country, right? My wife is still in Ethiopia and she's in hiding from from the government who's going after all the Amhara families right now. My wife is in, Cameroon, and she just got diagnosed with cancer, and there's no good treatment there. My mother's not a derivative, right? But my mother is 75 years old and in extremely poor health. And I understand that I can't go visit her in Ethiopia, but I would like her to travel to Dubai so I could visit with her in Dubai one more time before she dies. So these are the types of person-specific facts that you really need to work up. And these are facts that you likely won't know, right? Because if you're representing this person on an asylum claim, you never had occasion to ask them this stuff because it's not relevant to the 589 that you filed on their behalf. So it usually requires a re-interview of the client about these types of facts. Next slide, please. All right, and then once you come to learn these facts, you then need to place these facts in the knowledge of the agency. Because when push comes to shove, no judge is going to blame USCIS for not taking into account facts of which USCIS is not aware. So the main way I like to do this is an expedite request, right? I file an expedite request, not because I think it's actually going to be granted. It might get granted, who knows? But really as a means of putting facts into the administrative record before USCIS. So I file an expedite request saying, my wife in Cameroon was just diagnosed with cancer, staple the diagnosis to the expedite request. Now they're on notice of that fact. Other things, you can have the client try as an in-person inquiry, a congressional liaison, USCIS ombudsman, AILA liaison. Those aren't as good ways necessarily of getting evidence into the record, though. Really, the expedite request is pretty much all you need. What about a demand letter to the agency? Dear agency, please schedule my client within 60 days or else we will sue you. That probably doesn't work. And the reason is Rule 408, right, says that settlement communications are not admissible. So if you say a bunch of stuff in a demand letter, um, you may not be able to get that into evidence after the fact, right? So really just use the expedite request sort of function that USCIS has for different form types, and don't use the word mandamus or litigation or suit or anything like that. And again, the two reasons we're doing this are to get the Y facts into the administrative record so that you have it when you sue. And then also, again, judges like to see that, in any type of case, but especially in a case of this nature, judges like to see that you made reasonable steps to try to ask nicely before you went to court. Then the next thing you need to ask, again, let's use the example of a long pending affirmative asylum case. Is your client actually ready to go forward with the interview? Sometimes these mandamus cases are very quick. In the Arlington Asylum Office right now, if I file a mandamus today, I'm probably getting an interview in about a month and a half, an interview notice in about a month and a half. And that interview could be another 3 weeks thereafter. So do you have all the evidence, in your file, or is the client going to be scrambling to get evidence as soon as you get an interview notice? Um, do you have all the country conditions documents? But also, what are the country conditions right now, right? I mean, it, is this a good time? As we know, asylum, yeah, there's the presumption based on past persecution, but when push comes to shove, it's a present tense analysis. Is this a good time in the country's history for your particular client to be doing this case? Right. So again, if we have an Ethiopian Amhara client, this is an excellent time to be having an asylum interview right now. But if we have a Syrian client, boy, they may not want their interview right now at all, because right now the country's actually kind of doing okay, right, after coming out of the terrible Assad regime. But we're all worried that 3, 4, 5 months from now, everything might fall apart and get bad again. You know, if you've got a Syrian client, I would very much probably counsel them not to do a mandamus at this precise moment in time. Another thing you need to counsel the client is that this is federal litigation, and so therefore filing a mandamus places into the public record the fact that they filed the mandamus. Immigration dockets are semi-private. What that means is that the actual docket entries are only available to case participants and the public terminals in the federal courthouse. But the docket sheet is public. And so anyone can pull up the docket sheet off of Pacer, and these like bots that troll Pacer and then, post the docket sheets to Google. Long story short, if this person files a mandamus and then Googles their name 30 days thereafter, this will probably be the first thing that comes up. And so you want to tell them that so that they're not surprised to learn that the fact of this lawsuit, and thereby by extension, the fact that they're seeking asylum in the United States or seeking whatever it is they're seeking, becomes public record. And then every single client I've ever had ask me if there's going to be retribution, right? Is, oh my God, I'm going to sue the US government? Like, boy, in my country, if you do that, you're asking to be dragged, into the back room and tortured. Okay, I can sue them, but aren't they going to be pissed off at me and deny my case? I can confidently tell you that it's exceedingly rare. I don't want to say it's never, ever, ever happened. I've never had it happen to myself, but I've certainly heard stories. But for the most part, the agencies just see this as the cost of doing business. They don't take it personally. They don't care. It is extraordinarily rare that there's any type of retribution. And it's not even clear to me that the actual officers know that the person filed a mandamus or not. They just know that this case was put on their desk. I'm not sure that they know how the case was put on their desk.
Yeah, I guess
All right,
with
let me turn over to Zach now for the next
I'm going to
section.
talk about kind of the nuts and bolts of getting your case together. I'm going to run through kind of from the complaint through the motion to dismiss stage of everything here. And I'm going to kind of belabor this complaint stage maybe a little bit more than you would in other litigation contexts, because I think in delay litigation, it's extremely important to have a very, very well-crafted complaint. I mean, the standard is just a short and plain statement of facts that shows that you are eligible for the relief that you're requesting. But I think if you're going to have a successful mandamus or unreasonable delay claim, you really do need to spend some time crafting your pleadings and making sure that your pleadings are sufficient that it's not going to be kicked out at an early motion to dismiss. I want to echo what Simon stated about mandamus kind of not necessarily being accurate for what we're really asking here. There's really this APA, Administrative Procedure Act, unreasonable delay claim that we'll be making, and there is the Mandamus Act itself, which you can. Cause add as a cause of action and request that the judge grant this kind of extraordinary remedy for you. But really how we talk about things as attorneys, how judges review things, and really even in some circuits, the Mandamus Act itself is either superfluous or just entirely inappropriate to include. Like I'm here in the 10th Circuit, and there's precedent here stating that if you have an APA unreasonable delay claim, the Mandamus Act should not be included in your complaint. So do some research, but just to quickly go through the statutes that we're really basing our case on. The first is APA 5 USC Section 701 through Section 706. Section 706 is really your causes of action and where we find that basis where we can say that a court can order action that has been unreasonably delayed or unlawfully withheld by an agency. The other kind of subsequent statutes are things like when the action becomes litigatable, when does that right to bring the case actually vest with the client. Section 555 of the APA is where you find the statute that says that an agency has to resolve matters before it in a reasonable period of time. So that is just another basis for you to make that case that things have to be resolved in a relatively reasonable period of time. Those are not defined, so we go into case law as to what that actually means. But that's kind of the basis of what you're going to be litigating. And this is really the meat of your lawsuit. Like I said, the Mandamus Act, it does exist. There's 28 USC 1361, but it's considered an extraordinary remedy. It's one that you have to show that there is really no other right to relief that's out there for your client, which is where it is important to exhaust your administrative remedies, go through those expedite requests, congressional inquiries, things along those lines. And then you also have to show that there's not an alternative right to relief in litigation. So where we have these APA bases for getting these unreasonable delay claims solved, that's where we see judges kind of conflate the analysis and say, okay, essentially the APA and the mandamus claim are the same, so we're going to treat them the same. Or else, like in the 10th Circuit here, say, well, you've got the APA, so there is a different right to relief available to you, and so mandamus is not appropriate and you shouldn't include it. If I do include a mandamus cause of action, it really is just kind of this ancillary thing after I do a really in-depth APA analysis where I say, in the event that you find that there's no unreasonable delay under the APA, then we really do have no other right to relief. And in that situation, the Mandamus Act is appropriate. So just want to make sure that you do your research and that you craft your causes of action according to the precedent in your area. All this is going to be based on federal question jurisdiction. We're just asking, is this an unreasonable delay under the APA and the circuit precedent that's out there? If we go to the next slide, please. So that kind of brings up what is reasonable. There's a couple of statutes out there. We have 8 USC 1571B. This is in the kind of general U.S. citizenship and immigration services context, where you're litigating about an immigration benefit, and it says that it's the sense of Congress that an immigration application should be decided within 180 days of its filing. And then we have 8 USC 1158 D5A, which is in the asylum context. And we've got the specific language there stating that in the absence of exceptional circumstances, an initial interview for an asylum application should be scheduled 45 days after the application is filed. And then again, in the absence of exceptional circumstances, a final decision should be made within 180 days after the application is filed. But at 1158 B7, we do have a particular statute stating that there's no private right of action that those timetables are creating. So we have these unofficial timetables that Congress has set forth, stating that 180 days is really what we're looking at, but it's not a really explicit command in the same way that the post-naturalization interview statute has, for example. We're really just we have a general sense of Congress saying, hey, 6 months is kind of a reasonable way to look at things. So without an explicit statutory timetable, what you can look at is some of the data from the U.S. Citizenship and Immigration Services. They do have some fairly good data out there that they present. One, for example, is the historic median processing times for a given application type. You can go back about 5 fiscal years and see, all right, well, in fiscal year 2021, this was taking 8 months, and now it's taking 42 months. Judge, look at this. That's kind of like on its face, just unreasonable how quickly this has become this runaway train of nobody's getting decisions. And there's also times where it may be reasonable to file a Freedom of Information Act request ahead of an actual litigation that you want to file to get more detailed pieces of data and information saying really how long things are taking, what the process is for those things to be adjudicated and things along those lines. That really depends on the timeline of your client, the resources of your client. A Freedom of Information Act request can take some time if you just kind of let it sit on its own. So it may be necessary to engage in some FOIA litigation to get that response in a more expedient period of time than you would just by being in the queue. Not always necessary, but if you have some more, I don't know, particularized case that doesn't have a lot of data out there, or if you're doing some sort of mass action or a class action, then sometimes it's nice to have that extra data to fall back on. And then the last point is really that the agency doesn't or they shouldn't get to decide what is and is not reasonable. This is an argument that they make pretty frequently, and it really irks me. This is the offender shouldn't decide if what they're doing is proper or not. If they say that we've gone from 8 months to 42 months, but whatever, that's how long it takes, that's not appropriate. So that's where I think it's really important for us as advocates to push back on those and push back with statistics, push back with arguments, and then push back really with the client-specific facts that Simon was talking about earlier to show, all right, well, you say that 48 months is a reasonable period of time to do this application that takes 30 adjudicator minutes according to your publicly available data, but that's not appropriate, and let's have a judge figure that out on kind of an impartial adjudicator make that determination. Let's do the next slide, please. So I guess really when we're getting into the actual meat of the complaint, the first thing that you want to decide is where are we suing? This is your venue statute, 28 USC section 1391 E1 for a US government defendant. So 3 places that you could really sue. It's where the defendant resides, where a substantial part of the acts or omissions that caused this litigation took place, or where the plaintiff resides if there's no real property at issue in the action. It used to be that we would say, hey, Department of State, Department of Homeland Security, they're headquartered in District of Columbia. District of Columbia, those judges are really, really well versed in administrative law, so let's just go there. I can tell you now that is not the prevailing practice. There has been just such a flood of litigation in the District of DC and also the District of Maryland, which is where USCIS is located, that they will just file a motion to change venue and it'll almost certainly be granted unless you have your plaintiff residing there and can tie the offense there in some more meaningful way. And if your goal is to get a decision as quickly as possible, I mean, you're really just kind of shooting yourself in the foot there. You're going through this motions practice that you're going to lose for no real reason. So really, you're just going to be filing either where the substantial parts of the acts or omissions took place, or where your plaintiff resides. And where you do have some options, that's a really important decision point. If you have a plaintiff, for example, who resides in San Francisco, and their application has been pending forever at the Nebraska Service Center in Omaha, Nebraska, well, I can probably tell you that the Northern District of California is going to be a more favorable jurisdiction than the District of Nebraska. And not to say that some cases might not be better in the District of Nebraska, but there's just some bad case law in the Eighth Circuit. So, it's good to do some research, but where you have options, make sure that you're kind of looking into them. I see
Can
Simon's
I
got.
can I jump in on this super fast? So if a case is at a service center, but it's ultimately going to be interviewed at a field office, even if the file hasn't made its way to the field office yet, that's certainly good enough for venue to lie where the field office is. And if a client has moved from the jurisdiction of one asylum office to another asylum office, and they filed an AR-11, but the file is still at the old asylum office, I don't think that you'll get away with filing mandamus at the old asylum office just because the old asylum office hadn't yet gotten around to transferring the file to the new asylum office. I think you really have to just liaise with USCIS, get them to move the file, and then file the lawsuit where the new asylum office is, or even don't. I've just filed mandamuses, like where someone moves from Virginia to Illinois and the file is still in Virginia because they just haven't gotten around to sending it yet. I just file in Chicago and I said, look, they're supposed to have sent it. They haven't sent it yet. They will send it. They will interview it in Chicago. And so that's why we're filing here in Chicago.
I fully agree. I mean, the venue games that you have to play with at the beginning of this is they can be absurd. So, yeah, I guess beyond looking at the which venue is most appropriate on a legal basis, you also want to make sure that you're not going to be, kind of playing games and having to deal with a motion to change venue because you are quickly trying to say, all right, Eastern District of Virginia instead of Chicago right after you move. But anyways, first real decision point and really an important one for crafting your complaint. If we can do the next slide. So the timeline, I think this is important to understand yourself and then important to communicate to your clients. The timeline is really based off of the Federal Rule of Civil Procedure 4I, it's service in the United States and its officers. When you file your complaint, you're going to have to serve the Attorney General of the United States. You're going to have to serve the local U.S. Attorney's Office, and then you're going to have to serve the defendants as well. And they all have their own kind of specific spots that they need to be served at. After you filed your lawsuit, it is 60 days after the defendants have been served. It's 60 days for them to either answer your complaint or to file a motion to dismiss. I think that that first 60 days is very important. It's a really important time that you can pick up the phone and call your local U.S. Attorney's Office, or if you know the local AUSAs, to give them a call as well, just saying, hey, I've got this case pending, maybe on day 30 or day 45. Can we do something about this? Because oftentimes they can just resolve things on a more informal basis. Help, all right, no problem. We'll get you an interview scheduled. We'll push out our answer date and no big deal. If they're not willing to talk to you, or if it just turns out to be a case that USCIS wants to push back on, you're likely to get that motion to dismiss on day 60. That's kind of the prevailing practice, I think, unless you have just a truly slam dunk case. Once we hit that motion to dismiss, then we're at local rules, local practice, and we're into just the motions practice of litigation. If they file a motion to dismiss, it's likely going to be under Section 12B1 of the Federal Rules of Civil Procedure for lack of subject matter jurisdiction, or 12B6 for failure to state a claim. And we're just going to be doing motions practice. You're going to respond, they're going to reply, maybe there's a hearing, and we'll talk a little bit more about kind of the details about that and what needs to be, what the arguments, I suppose, are for those. It's possible that they do like a combination motion to dismiss and motion for summary judgment. I think those are a little bit more rare. I haven't seen too many of those recently. If that happens, it's possible to try to get discovery at that point. There is very limited discovery in these types of cases, but if they file a motion to dismiss and you need something in the record, you can do this thing where you file a declaration under Rule 56D of the Federal Rules of Civil Procedure. I'm saying essentially, I can't respond to this motion for summary judgment with the facts that are in the record, so we need some supplemental discovery before this actually happens. More likely after this motion to dismiss, motion for summary judgment, potentially you get the administrative record filed with the court, which is just this is what's happened in the case, this is what's been filed, and you may have the option to try to supplement it. It's pretty difficult, but you can try to supplement the administrative record saying this is not everything that we need, this is not everything that the agency considered or is considering. So we need, again, more facts in the record. But really what you should expect to have your case be heard on is what has been filed, which is, again, why we want to get everything in the record at the beginning through expedite requests and things along those lines, and anything that's judicially noticeable, any kind of publicly available information that's not really subject to dispute, government website data, things like that. And then finally, you'll have a motion for summary judgment. That's where the case gets resolved. You're not going to have a trial. This is all just a question of law. So, is this or is this not an unreasonable delay is the ultimate question. And the judge will make a decision based off of that, and that will resolve the case in its entirety at the very, very end of the process. Um, it can take a long time, I will say. If we get all the way through the motion for summary judgment, you may be looking at well over a year to have a decision from a judge. Even at the motion to dismiss stage, depending on the venue you're in, it could be 9, 10 months before you get a decision from a judge. Things are very busy in the courthouses right now and expect them to get busier. So this is just something to make sure that your clients are aware of, that you may be in for a little bit of a wait if the government decides to fight things. So you want to make sure that everybody's on the same page and nobody's disappointed or nervous, I suppose, about how long everything's taking. We go to the next slide, please.
And Zach, can I just jump in really quickly? We had a question from the audience. Do you see a difference in the level of willingness to settle these mandamus cases out of court at the motion to dismiss stage under this administration?
So
I would say not yet. No. I mean, TBD what's going to happen, but I would say as of right now, I haven't seen that.
I agree. I did have one case where we were pending a settlement where the attorney said nobody in my office is permitted to grant like a written settlement at this point, but we were still able to resolve things more informally at that point. So they're still willing to resolve things. Just it seems like there's a lot of chaos in DOJ right now, which is, I think, understandable. So jurisdictional challenges is something I'm going to belabor a little bit. I mean, there is just an entire graveyard of litigation of case types that we can't really file under anymore, and that's all based off of I mean, not necessarily bad litigation, but cases that have been kicked around by judges really, really reading broadly into this jurisdictional stripping statute of 8 USC 1252 A2B2. I think it's really, really important at the outset of your case to look to see if this is something that judges in your circuit have already made determinations about, if this is something that's potentially at one of the circuit courts of appeal, your particular type of case, and whether you're likely to run into a big issue with subject matter jurisdiction in the actual litigation of your case. So section 8 USC section 1252 A2B2 is really specific for USCIS affirmative applications. I mean, 1252 A2 is about matters that are not subject to judicial review. A2B is specifically titled denials of discretionary benefits, which if you think, well, that means that we're talking specifically about actual decisions, you would be a smart person, but you would be wrong. The government has made very, very expansive arguments about specifically A2B2 and has stated that it's really about the pace of adjudication as well as the actual adjudications themselves. But to, I guess, be more specific, section A2B2 states that courts lack subject matter jurisdiction over decisions or actions of the Attorney General or the Secretary of Homeland Security that have been specified to be in the jurisdiction of those of the Attorney General and in a discretionary manner. And so any discretionary determinations are potentially subject to this jurisdiction stripping statute of 1252A2B2. Decisions or actions fall into that kind of ambit of this statute. And the only real exception is granting of relief under Section 1158A, which is for asylum applications. So asylum applications don't have this jurisdiction stripping problem, but anything that's in the discretion of the Attorney General or the Secretary of Homeland Security by statute is likely to run into some major issues. Both in the actual challenge of a grant or denial of the application, or the pace of adjudication for these types of applications. That said, I think that one really important point here is from Raina v. Hott here in Fourth Circuit. It's a 2019 case that it does state that when 1252 strips the courts of jurisdiction to review the decisions or the actions of these discretionary determinations, that discretionary authority, it's not something that can be implied. It has to be explicitly conferred in the statute. So you have to have an explicit statutory basis that the government can point to saying that this is a discretionary action on part of the AG or the Secretary of DHS, and not just something that we're implying to be a discretionary action. It's a huge issue. I mean, we really run into this a lot. It's been something that they've been really expanding their arguments on, and judges are buying this. So you want to be careful, and you want to make sure that you're doing your research ahead of making any arguments. That said, there are some ways around this. So under the APA, one of the ways is to point to final agency action. In the asylum context, one of the ways that works and sometimes doesn't work is to argue about their policy regarding last in, first out. This is their policy of saying, all right, we're going to take the most recently filed applications and then make determinations on them before the earlier filed application. So somebody who filed an application today is ahead of the person who filed an application yesterday. You can say this is a policy decision and make a challenge on that, rather than saying that this is an unreasonable delay for my person in particular. And that's really a much more expansive lawsuit, but and not one that I think that you want to rest your entire case on. But it can, I think, inform the unreasonable delay by saying we've got this policy that's just bonkers. Another one, if you just can point to that this is not this is a non-discretionary action by the agency, then you can get around this 1252A2B2 issue altogether. And one that the government really argues in a lot of contexts, but especially in the asylum context, is that there's sometimes no meaningful standards by which the court can measure whether a delay is reasonable or not. And so that's where getting some data behind your lawsuit is really important. We've had this case, Hubbard v. Chertoff there. This is a 2008 case, so it predates a lot of the 1252A2B2 litigation, but it does touch on some of the arguments that the government's making now. There were some cases that were being argued in this way in the 2000s, and they did go both ways in some capacity, but there's I think it does a really good job of dissecting the internal inconsistencies that courts make when they're saying certain things, and specifically this next point that I've got, that unreasonable delay can sometimes reach unlawful withholding status under 5 U.S.C. Section 706. So the I guess way to think about this, and I'm sorry to really be belaboring this point, but there's two parts to the unreasonable delay statute here. The courts can order on agency action that has either been unreasonably delayed or unlawfully withheld. And courts have for years now, since the 2000s, said that there's a certain point that unreasonable delay can reach this unlawful withholding. They say it in a really awkward way, but that's the way that I've read it, to say, okay, maybe 42 months right now is not unreasonable, but maybe there's some point in the future where 80 months we could say, well, they're just not adjudicating these applications altogether. This is kind of a programmatic thing. And we can change this unreasonable delay litigation where I don't have jurisdiction into an unlawful withholding claim where I do have jurisdiction. And that's one way I think that you can try to get around some of these unreasonable delay arguments, if you can transform your unreasonable delay case into an unlawful withholding case, it makes it just a much more powerful way to litigate against the government. And just to give you one example of how we have been doing things in Colorado, I'll give you the asylum context. So we don't have an asylum office here in Denver. Just we're apparently not big enough for that. So what we have is the Houston asylum office does what's called circuit rides. They go to various asylum offices in their jurisdiction, and they do about 2 week stint where they just hear a whole bunch of asylum interviews and then move on to the next office. Well, about 2020, those just shut down entirely because COVID happened and nobody was doing any in-person anything. So we did not have any circuit rides happening whatsoever. Then about 2023, when we left Afghanistan, we had Operations Allies Welcome, and that was just a huge influx of Afghan asylum applications. And suddenly we had the Houston Asylum Office doing circuit rides back up to Denver solely for these Operation Allies Welcome asylum cases, which then we could say, hey, everybody who is not in this case, this kind of category, this particular track of asylum applications, is not having their cases heard categorically. Clearly, they have the capacity to do this. Clearly, they will be doing this in other contexts, but they're not doing it here, which means that the rest of us are having unlawfully withheld adjudications of our applications, and that's met with some success. There was a lot of settlements through that line of argument, and even to this day, we're still seeing really just. I mean, we just kind of finished up those OAW cases, so we're starting to see cases that had expedites and cases that have had judicially mandated interviews. Those are the two that are really being scheduled in Denver right now. Simon, I see you want to jump in.
Yeah, I agree with that fully. The far and away the biggest type of category of mandamus cases that I do are pre-interview affirmative asylum. And Arlington Asylum Office is my home base, and we roughed out some arithmetic. We rough out some arithmetic in our complaints and we show that, basically this person who filed on such and such a date, the way they're going is likely to be scheduled for an interview in an ordinary course in 147 years. Their lifespan is not that long, and therefore their statutory right to apply for asylum under INA 208 has been unlawfully withheld from them, and their case has been constructively denied. I recently had a motion for summary judgment hearing on one of these cases. I threw, 7 different arguments at the judge for why she shouldn't grant summary judgment to the government, but the one that she was persuaded by was this argument that essentially, if the current scheduling process will push the interview out past the person's natural life, then this is no longer a delay case, it's now a denial case. And she actually ordered me to go into discovery so that I can now prove that up with admissible evidence. And of course, TBD whether the government is actually going to sort of provide that discovery or just roll over and schedule this guy for an interview.
So yeah, but in the end, I mean, it looks like it's a successful strategy beyond just in Denver. But that is the way I think that a lot of times when you've got this, I mean, these cases that just aren't moving, and you can show that it's a more programmatic thing, you have a lot more weight behind you if you can show unlawful withholding rather than unreasonable delay. And that goes for the asylum context. I think it's an easy example for the asylum context, but we had a case in the District of Nebraska over a specific waiver application in 2023, where I was mentioning, there was a 8 years, 5 years ago or 8 months, 5 years ago for the adjudication time, and then it's 42 months now. And we said to the judge, hey, at a certain point, they're just not going to be adjudicating these applications whatsoever. And the judge made this kind of middle point argument where, hey, I don't know if I have jurisdiction now, but if you can really show that it's going to reach that level, then maybe at that point I'll retain jurisdiction. That's on appeal, but it's still kind of the same thing. Even in this waiver application, which would fall into this A2B2 category, where we're able to make it an unlawful withholding claim rather than an unreasonable delay claim, we can sometimes get around these jurisdictional challenges. Sorry, I know I belabored that. It's really important. It's something you really, really need to look into and really look at the case law on your your particular application type before you file, because like I said, there is just a graveyard of types of applications that we can no longer sue over because there's been so much litigation on this and so many decisions saying, sorry, subject matter jurisdiction does not apply here. So I guess with that, can we go to the next slide? All right, so let's talk a little about the substantive standards for what is reasonable and what's not reasonable. This is for most jurisdictions, not everywhere it follows this. Like the 10th Circuit has a different standard, but they're all kind of the same. If they're not exactly this Telecommunications Research and Action Center or the track factors, there's something pretty similar. So this is what the court is weighing when they're making a determination as to whether a case is or is not unreasonably delayed. Now, they all
Zach,
are called
right.
factors. I've always thought that that's a little bit of a misnomer because it's not like you add them up and say, plaintiffs got 2, 3, and 5, and government got 4 and 1, and because of that, plaintiffs win. These are just things that the judge can weigh to determine whether a delay is or is not unreasonable or it is reasonable.
Zach,
So
before
that's why.
we jump in detail to these factors, I just want to flag there was a question about your point, or actually it might have been Simon who said this, but the question was around how you do the math to predict how many years till scheduling to make it that wrongful withholding
Yeah,
unlawful.
so USCIS asylum offices release fairly detailed month by month statistics about their backlog. And then from liaison notes, we have at least a statement of how many backlog interviews they're doing per, month. And then we take them at their word for the purpose of the arithmetic, for a complaint that they're doing the backlog interviews in strict reverse chronological order. And then, I just do some like really, really back of the envelope math, basically. But again, now we're actually going to have the opportunity, if the government continues to defend this case, we're going to have the opportunity to do some discovery on this and really prove it up with evidence.
And then that's also, I guess, one point where it's kind of important to tap into your local immigration bar to get that or in on the ground knowledge. I was talking about the Colorado side of things, for example. Like there's only 350 of us in Colorado, so it's not a huge bar. We're all pretty tight knit, and so the folks who are doing these asylum interviews, there's not many of them right now, and so they're able to have these conversations with the asylum officers off the record. Hey, how many of you guys are coming up for just the last in or the very farthest track of folks? And the asylum officer said that it's totally voluntary circuit rides right now. And so really, unless they're mandated to come up for a judicially ordered interview, they're only doing the expedited cases and the Operation All Eyes Welcome cases. So we're able to incorporate those statements and just allege that, hey, this is what we know based off of what we've heard around the asylum officers. Um, yeah, tap into the immigration bar. There's a wealth of knowledge there. But all right, jumping into this. So this is the actual standards that you're going to be trying to prove. This is what you're going to be alleging in your complaint in some depth. I think that's important to do. There's 6 factors really. The first is that the time that the agency takes to act has to be governed by a rule of reason. It doesn't have to be the best rule of reason, but it has to be a rule of reason. And if you can show that they're not following that rule of reason, then the factor is very heavily weighted in your side of things. They're following a rule of reason, generally the court's going to just say, okay, they're doing something in a way that they think is best, so we're going to defer to them on that side of things, and they'll get that factor. The second is whether Congress has provided a statutory timetable that the agency has to follow. Now, when we talked about those senses of Congress for the asylum applications and then the immigration applications in general, those aren't explicit timetables, so it's not something that's going to weigh in your favor if it's taking over 180 days. Here, what I like to do is just kind of acknowledge that. I say, hey, okay, we've got these statutes that say sense of Congress is 180 days for this to be completed. We understand that that's not an explicit timetable, but it should inform the court that this is taking an extremely long time in comparison to what Congress had intended for these to take. It's not going to weigh in your favor, but you're at least throwing some argument out there. Three and five are typically considered together. This is the impact of human health and welfare, and just really the impacts of the delay as a whole. And this is where I like to bring in things like declarations from the plaintiff, if we can get them, kind of talking about their hardship in a little bit of depth and in a little bit more of a human way. We of course want to have all of this in the administrative record because that's the only thing that the court can ultimately consider in a decision. But when you're at the pleading stage, having that kind of human element to it, I think makes it a much more powerful complaint. And then you can get some of the details in the complaint and in your causes of action in more detail than you would otherwise. Number four, the effect of expediting on agency activities of a higher or competing priority. That typically just means everybody else who's in line. And this is one where the agency will win pretty frequently. They've won entire cases where they've lost four of the six factors, but they got number four. And their argument is essentially, come on, Judge, we're just moving this person from the back of the line to the front of the line. Everybody else is going back one space. What's the point of this? We're just rewarding somebody who has the resources or the wherewithal to sue, and everybody else is being disadvantaged by this. Judges have bought it, so that's something to be prepared for, and why you really want to be able to show that it's something more than just jumping the line. There's a need to do this beyond just this person wants to go faster. The last one is whether there's been any agency impropriety that's contributing to the delay. The factor itself is specifically stating that the court does not have to find impropriety in order to find that there's been an unreasonable delay. So oftentimes it's just neutral. You say, hey, there's no impropriety that we found and we're not alleging any, so this is a neutral factor. But if you do have impropriety that you can allege, I mean, it's kind of a gimme that your delay is unreasonable. If there's some agency impropriety that has caused this delay, that's not per se an unreasonable delay at that point. So anyways, you want to make sure that you're alleging these in some detail in the complaint. Can we do next slide, please? All right, and I guess other point of this is that the track factors are not exclusive. This is Gonzalez v. Cuccinelli. There's really two pieces here that I think are important. The first, before the ellipses, is that the Supreme Court has not provided clear guidance on how to determine how long is too long to wait for an agency adjudication. But track is what people use. It's general guidance, and it's how the courts are making these determinations. So that's your first part of it. This is just what it is. The second part of this is that the district court's not limited to these factors, and it's not required to use them. So you could have a court that says, I'm not going to use these factors right now. I'm going to go in this opposite direction and look at all these other facts that are in the record as to determine whether this is a reasonable or unreasonable delay. Track is guidance. It's not your kind of, like I said, this weighing of six things to determine who wins and who loses. If we could go to the next slide. And, I've really been belaboring that we need to put this in complaints. And for anybody who litigates, you may know that that's probably not what the actual rules require. I mean, a complaint is a short and plain statement of the facts that show that you are eligible for the relief that you're requesting. So why are we alleging so many in-depth facts and making legal arguments in the complaint? It's because at the motion to dismiss stage, the judge may actually rule on the merits and make a determination about who wins on the track factors just based off of your pleadings. So you want to make your pleadings very strong. I mean, we've got, it's not even just district by district or circuit by circuit. Within a district, you may have certain judges who say, yes, absolutely, I will review track factors at the motion to dismiss stage, and you'll have others who say, no, I don't think that's appropriate. So we've got, yes, Ahmed v. DHS, they will, and no, Begum v. Department of State, they won't. Going back to Gonzalez again, This is a case that they did determine that it was inappropriate to review the track factors at that stage. We see this quote, on the record, we lack sufficient information to resolve this issue on a motion to dismiss. A claim of unreasonable delay is necessarily fact dependent and thus sits uncomfortably at the motion to dismiss stage and should not typically be resolved at that stage. But here's the point that I think is really the main focus of this quote. We also think that the plaintiffs have pled sufficient fact to show that their interests are weighty, implicate health and welfare, and are harmed by the long wait. The agency may be able to refute these contentions, but at this stage, we may review only plaintiffs' pleadings. So really what seems to have won the day here were the plaintiffs' pleadings. They had some very, very well pled facts. They had some very, very detailed complaints and things along those lines, which let them overcome this motion to dismiss. Where otherwise, if it was just saying short and plain statement of the facts, this is what happened. This is when I filed the asylum application. This is how long I've been waiting. This is an unreasonable delay under the APA. They may have lost at that motion to dismiss stage without having this great opinion from the Fourth Circuit. All right, we move on from this slide. Simon, do you want me to talk about discovery or do you want to take it from here?
Yeah, I think this is me. Okay, so once you get past the motion to dismiss, so first of all, let me back up and say, we've sort of been dancing around this, but I'm just going to come out and say it. What your client wants in this case is their benefit adjudicated, right? Not a judicial determination that their benefit ought to be adjudicated. And a judicial determination that their benefit ought to be adjudicated is one way to get the benefit adjudicated, but another way to get the benefit adjudicated is to just get the AUSA to lean on USCIS to adjudicate the benefit, right? And so that is a lot of what we're doing here, right? We're preparing every case to take to the mat so that we don't have to take every case to the mat. So, this is really sort of a narrowing funnel of how much stuff are you actually going to have to do in any one of these cases, right? You'll file your complaint. That'll result in a certain number of them getting adjudicated. Let's say we have 10 of these, right, that you're all doing in the same week. You file 10 complaints. A certain number of them, they're just going to adjudicate it upon service of process of the complaint. And you get to the motion to dismiss, right? You might have to oppose 4 motions to dismiss. Well, if you survive those, of those 4, maybe they'll go ahead and say, fine, whatever. And they'll adjudicate 3 of them, right? And then one of them, for whatever reason, they're still going to make you take it to the mat. Well, the next step after a motion to dismiss is discovery. But you don't get discovery, Federal Rule of Procedure 26 discovery based solely on the fact of surviving a motion to dismiss as you do in general civil litigation. You have to make a showing that discovery is necessary. Bad faith, of course, but an incomplete record is really sort of the main basis for discovery in cases of these nature. We can go to the next slide. So when you're dealing with a motion for summary judgment in the Fourth Circuit, Zach discussed the Gonzalez case, which says that they shouldn't do track on a motion to dismiss. So for the most part, what I've found is that the AUSAs in the Fourth Circuit will respond with a motion for summary judgment as their first responsive pleading. But in other circuits, take the Ninth, for example, if you survive a motion to dismiss, then you're headed towards a motion for summary judgment. So in any event, remember, motion for summary judgment is where the rules of evidence really kick into play, right? And this is always to our favor because the USAs get extremely sloppy in these types of cases, and the immigration agencies, whatever the immigration agency, are not used to actually having to deal with the federal rules of evidence, and so they're not used to producing admissible evidence. So remember the subsections of Rule 56 that require that summary judgment motions be supported by admissible evidence. And the 2 types of rules that come into play are the hearsay rule, but also the best evidence rule. All the time I get these declarations from USCIS, officials, or if it's a different type of case, maybe from an ICE officer, that purport to describe the contents of a writing, right? You can't do that. The best evidence rule says you can't do that. So one of the things you might want to do, and these are 2 cases in which that was done successfully, is just move to strike their inadmissible supporting documents, right? Because if you can cut the legs out from under them, they don't have, if you, they don't, they can't continue to stand, right? If you manage to strike key evidence that they filed in support of their summary judgment motion, the summary judgment motion can't be granted because they won't be able to prove with admissible evidence the lack of any genuine dispute of material facts and their entitlement to judgment as a matter of law. The other thing you can do is you can file a Rule 56D motion. Rule 56D, here's a great case out of the Northern District of California in which that was successful. I've had a number of other district judges follow this Munoz Barba case because they're really persuaded by it. And 56D says that if the party opposing summary judgment can show by affidavit that they have been unable to develop facts that are necessary to oppose summary judgment, then summary judgment must be deferred so that that discovery can take place. So I want to point out two little salient features of 56D. One, by affidavit. You have a 56D motion, or you can do a 56D by motion. You can file a Rule 56D motion, or you can have it be essentially an argument, a section in your opposition to summary judgment. I like to do the former, just because I get an extra brief when it's my motion. I get the last word. You must include an affidavit. A 56D can be denied on procedural grounds if you don't include an affidavit. The affidavit can and normally is signed by you, the lawyer, and it's crystal clear that a 56D affidavit can contain hearsay, right? You can have hearsay explaining why there exists non-hearsay evidence that you ought to be able to discover. And then the other thing is the word necessary, right? You have to make a showing that it's necessary to oppose summary judgment, not that it'd be nice. And you have to specify, I honestly forget if this is in the rule or not, but basically judges want you to specify with precision the exact discovery that you need, not just like, we'd like discovery on the following topics, but specify very precisely what discovery, because they want to know that you're not going to be like, all right, if you let me into discovery, I'm going to I'm going to send a, deposition notice to Christy Nome, right? They want to know that you're going to be laser focused. Okay, next slide, please. We talked about most of these. These are some of the common government arguments on the merits of these cases. On track factor 4, they argue line jumping. A predicate to the concept of line jumping is proving that there is a line and that's their burden of proof. Don't just take their word for it. It is true that if there is an orderly line, moving one person from the back to the front serves to move everyone else back in line. Now, what you can point out is that it takes 4 hours to adjudicate one of these cases or 20 minutes to adjudicate one of these cases, and there's a gazillion people in line, and so therefore you're affecting the line by 0.0000003%. But even sort of conceptually prior to that, if they want to argue line jumping prejudices other applicants, they have to prove as a matter of admissible evidence the existence of a line. Because if it's an unorganized scrum of people, imagine just a mass of people in front of a door. Plucking one person from out of that mass and putting them through the door does not actually prejudice anyone else in the scrum because they didn't have a place in line to begin with. They will argue congressional appropriations. They'll say, look, we only get so much money to do these cases. We're doing the best we can. They'll argue COVID. Hey, man, we got real behind in COVID and we're still doing our best to catch up. Operation Allies Welcome. Hey, there was this class action that said that we had to do all these cases really fast and we only have so many officers. And so we had no choice but to kick the other cases a bit. The border crisis, these are all types of arguments that they'll make. There's lots of cases responding to these, but the key point is that these are facts. Don't let them make this in briefing without facts to back it up. And those facts have to be admissible facts, not some generic declaration from, the head of the service center or the head of the asylum division. Next slide, please. And then just two closing thoughts before we get into question and answers. Again, as I said, your client's goal is to get the benefit adjudicated, not to win the lawsuit. Um, the way you do that for large numbers of clients is by preserving a sterling reputation, right? You need to be able to take, the government needs to know that you are able to take any given case to the mat, and thereby you will have to take fewer cases to the mat. And the way you do that is twofold. One, um, by showing that this case is one that you are able, willing, and ready, and it's like it's got everything all lined up, with your complaint, um, a really well crafted expedite request that was filed prior to the complaint that's maybe Exhibit A to your complaint, et cetera. But then also your reputation as a litigator. They know that you can do it if you need to. They know that you're not going to just roll over as soon as they file a motion to dismiss. And then on that note, though, let's not kill the goose that lays the golden eggs, right? If we get in the habit of filing really garbage mandamuses, over and over and over again, we're going to provoke a backlash from the agencies, from the individual U.S. Attorney's Office, from oil, in which it's going to be really bad for all of our clients, both as individuals and as an advocacy community. So I guess with that, we're happy to take any questions you all have.
And if folks are not comfortable coming off mute for any reason, feel free to put stuff in the chat. You can DM me directly. I thank you to everybody who's already put questions in. And thanks, Zach and Simon, for letting me interject as you were talking to get those answered.
I was just going to say, and we spent a long time talking really about like internal USCIS, in the United States adjudications, and not as much time talking about consular adjudications.
That's
There
true.
is kind of a whole separate set of issues that we could spend hours on with the consulates, but happy to answer any questions on that. Just that wasn't really the focus on the presentation for sure.
Yeah, definitely state is far more likely to push back and really oppose these and make you take it all the way. Not 100%. I was very surprised that state rolled over on a case recently. And weirdly, they push back harder on immigrant visa than non-immigrant visa cases. I don't know why, but they do. But yeah, definitely don't do a state one as your first mandamus, right? Like if you need to do one against state, team up with someone who's handled one specifically against state before.
Not to put either of you on the spot, we did get this question before, and just acknowledging it because it's in the main chat now. There definitely is an interest in having a copy of the slides. If you don't know your thoughts off the top of your head, we can also discuss on the back end. So just don't want to put you on the spot for it.
Sure.
Thank you guys. I
Okay.
appreciate it.
Thank you so much for the presentation. I did have a question since you mentioned the Syria example, since we're trying to draft a mandamus for someone who's been filing asylum from Central African Republic. If you happen to have any details on whether now is a good time or a bad time to be filing on their behalf.
Well, I mean, I don't know the country conditions in Central African Republic right now and if they've, changed significantly, but a lot of it is a little bit of crystal ball looking, right? Are the country conditions likely to get worse for this particular category of people in this particular country, or are they likely to get better, in which case you'd better try moving on that ASAP. I don't know anything about the CAR in particular, but it's terrible that asylum applicants have to file a mandamus in order to get adjudications. But the one kind of bright spot about it is that we get to time the adjudication. If you have a country that's very volatile, right? I mean, if it's Eritrea, like Eritrea has been Eritrea and it's going to keep being Eritrea. But if you have a country that's volatile, it means we kind of get to time this to a certain. We get to we file an affirmative asylum application, and assuming our client doesn't get LIFO'd, we get to choose when that's going to be called for interview. Not it doesn't happen at random.
Anybody else? And if not, we don't have to keep everybody on the Zoom. Wanted to make sure we had plenty of time if there were questions. So we The three of us are available. Really, most importantly, Zach and Simon are available until 2, but more than happy to give them and everybody else time back if we don't have anything pressing.
We give examples for each of the track factors. All right, so I'll do some more of the business side of cases that it's just more of my wheelhouse. So let's see. I'll do a state one because we did that not too long ago where we are pretty successful on this. So Department of State has priorities post-COVID for how they're going to adjudicate non-immigrant visa applications. They say first this, then this, then this, then this, then this. That's their rule of reason. So first thing that we get to say is here's what they've published or what we've gotten from a Freedom of Information request as to what their rule of reason is. We can see that this K1 fiance visa should be in the second priority, but it is in fact not being honored in that way, and they're not being scheduled whatsoever because we can see from the statistics that they have scheduled 40 K1 visa applications and 7 million B2 applications. So here's one where they have a rule of reason that they've set forth, but they're not following it. Has Congress set forth a timetable? Again, here's this 180-day sense of Congress. It's not an actual statutory timetable that they have to follow, but hey, Congress wants these to be done fairly quickly, and they haven't done it here. Then we go into 3 and 5. Hey, the fiancés in the United States, COVID's been going on. There's all these things happening. This person's in poor health. Their fiance is in poor health. They have children together potentially, and they're in a dangerous situation in their home country. Because of all these reasons, there's actual human health and welfare at stake here. And because this is being delayed, and because they're not following their own rule, there's actual risk of danger and death, basically. So because of that, 3 and 5 very heavily weigh in favor of the K1 fiance plaintiff here. The effect of expediting on activities of higher or competing priority, well, that doesn't apply here because they are the higher or the competing priority. They are supposed to be priority number 2, but they're being placed as priority number 7, instead of the actual rule of reason, which puts them near the top. So this can't possibly have an effect on agency priorities that have a higher priority because they are the higher priority and they're just not actually being taken care of in the way that the Department of State, who we love and they're so great and they've made a wonderful rule of reason, but they just are not following it. This particular consulate is being improper. Is there any sort of impropriety here? We don't believe that there is. We would need discovery to see if there's been any sort of internal communications about how much they hate K1s and something like that. But we, at least at this point, are not alleging that there's been any sort of impropriety here. And because of this, we've got number 1, number 3, number 4, and number 5 very heavily weigh in favor of the plaintiffs. Number 2 and number 6 are neutral. This means plaintiffs should have a determination that their delay is unreasonable.
Thank you. So if you have some example of what would be an impropriety, something that you've seen, and then one final question, how do you argue against, oh, we've only got a budget for XYZ?
So for impropriety, in the EB5 context, this is for immigrant investors who have thrown $1 million into a U.S. business and are going to create 10 U.S. jobs and all that. There was a point where we got some internal communications, whether through FOIA or some other avenue, showing that one particular project had some connections with a congressman and so was expedited improperly in comparison to other projects. And so we said, hey, there's some tomfoolery going on here. My plaintiffs are behind in line because these other people had political connections. That's not okay. This is an impropriety. Let's fix this essentially. And I apologize. What was the second question?
Yeah, I mean, I can give an
How do
example
you
of
argue against budgetary
impropriety.
constraints?
On the impropriety question, I mean, if you're familiar with the Orantes case from the 1980s, the whole factual predicate of the Orantes case was that in the 1980s, the Reagan administration had an opinion on the war in El Salvador, and our opinion was that the government were the good guys and the FMLN were the bad guys. And so as a result, people who were fleeing the FMLN were sort of prioritized for asylum adjudications and were winning asylum, and people who were fleeing the government were deprioritized for asylum adjudications and were not winning asylum, right? So that was an example of our foreign policy, um, our nation's foreign policy sort of alignment being improperly used on the to make scheduling and determinations of substantive asylum decisions. Many people would say that something similar is happening right now with Russians who are seeking asylum, right? I think there's strong evidence that ICE is not will. I know this doesn't go to the merits determination, but ICE is not willing to parole Russian asylum seekers out of detention in the manner that they are people from other parts of the world. So there are types of improprieties that can be found, and certainly under this administration, probably there will be more and more.
And then on the budget point, how you argue against the budget point, I think there's two real ways there that I've done it. One is it's not the fault of my plaintiff that you have either budget issues or that you're not allocating your budget properly. Plaintiff should not be penalized for bureaucratic inefficiency. And the second one is you just raised your fees by an incredible amount in order to address these backlogs, and we haven't seen any impact on that. So that argument is clearly some BS because you just had this massive, massive influx of cash, and where is it going, basically?
Thank you.
I think the next question is, would you file a mandamus for an asylum case that has already had the interview, but no decision has been made since the interview happened in 2019? Looks like that got
Yeah.
a +1 from somebody else.
Definitely. Absolutely. Yeah, I would totally do that. And I've done that on a great number of cases. My personal sort of soft line in the sand is 9 months. I think if it's been 9 months since an asylum interview, you can mandamus it without any fear that they're going to push back at all. They're almost certainly just going to adjudicate. In cases that have been pending for that long, what I found is that sometimes they want to re-interview. Those re-interviews can take as little as 45 minutes. But I don't recall ever having not been successful on a mandamus on that sort of type of posture where the interview already took place and it was, it's just been a very, very long time.
Thanks for that. And one other question that came to me directly. So one of you may have mentioned psychological stress in terms of waiting, but that's not enough in terms of harm. So how would you or a judge, or how do you think a judge would evaluate severe distress, including PTSD and contemplated suicide, where you have documentation by a medical health provider and included that in a previously rejected expedite request? And in this particular case, this person's talking about the delay in scheduling the interview so far is about 8 years.
Yeah, I think that sets it apart. I think that, but the psych eval would really have to tie the PTSD and the symptoms into the delay and not the underlying trauma that occurred from the persecution, right? But I do think something like that. The whole point is, if all you're saying is something that literally everyone can say, then you're saying nothing, right? But if you're saying something that only your guy can say, then you're saying something. And so I think that would be an example of something rather than nothing.
Just to add to that a little bit, there is a certain point where even if you're saying nothing, legally this is still a problem. If you're saying it's been 10 years since my asylum application's been filed, and this is a horrible program, I'm never going to get my interview, 147 years before I'm going to be scheduled for my interview. Even if you don't have particularized harms, you can certainly still file and say, this is unreasonable just as a matter of law, regardless of if I in particular am suffering more hardship than somebody else who filed the day before me. The agency is acting improperly here, and the agency needs to be held to account.
I mean, I've never had someone who can't, within 20 minutes of interviewing them, come up with some particularized harm, even enough for 3 sentences in a this can be 1 paragraph in the complaint, right? It doesn't have to be, page after page. But if someone's been here for 10 years on pending asylum, I guarantee you there's been an occasion in which their EAD was delayed and it caused them to lose their job or have to go on administrative leave, right? Like, there's some job that they got passed up for, and they have reason to believe that the reason they got passed up for is that they're on a short-term renewable EAD. There's some class that they thought about taking at the local community college that would help them advance in their profession that they couldn't take when they realized they would have to pay out-of-state tuition rates. I mean, everyone's got something, right? Um, Now, to be totally honest, there are cases that have been pending for so long that we don't bother with the expedite step. Um, but I do think that best practice is what we said in the presentation, which is to always do the expedite first.
Absolutely.
Thank you. And then going with another kind of hypo case example, could you give your thoughts on whether when laying out a client's particular harms, harms that have already come to pass are as effective as harms that are imminent or may happen? So the example given is, you have family abroad abandoning the client effectively because the asylum process has dragged out so long, and there's this like breakdown of trust in the family, or the family's threatening to kind of just like cut them off and abandon them altogether.
Yeah, no, I've definitely done that. I mean, my wife left me because she got tired of waiting in Ethiopia for me to bring her over. I've definitely pled facts to that effect. I mean, that's not going to happen again. The wife isn't going to leave him a second time, but certainly those are facts that you can use.
And then another one, is there a benefit to asking for expedited review, excuse me, more than once?
If we have a case in which prior counsel did the expedite request and it's garbage, then yeah, I'll do another one. And again, if let's say we're talking about a case that's only been pending 3 or 4 years, and prior counsel did the expedite request, and the expedite request, some people do these expedite requests and they focus on why the case ought to be granted, right? Like why this person suffered past persecution on account of a particular social group. That's not really the factor for expedite, and it's not really a track factor. So yeah, we'll do another one if a previous one was done and it's just not very good.
And how long would you wait to file mandamus after filing for that expedited review? So for example, when can you say that you've exhausted all those administrative options?
I'll shut up and let Zach ask because I've been answering all the questions. But for us, the asylum office denies these within a week or two. You don't really have to wait very long to get a denial. Other USCIS components will just ignore you, and so I just wait 31 days. That's my personal practice.
We actually get approvals of expedite requests here, but then just nothing happens. So,
That too.
that's, I guess the other piece of this is you could have an approved expedite request for somebody who has, I don't know, their asylum pending for 2 years, and you have all the great facts in the record at that point. But then you have to, again, just look at the kind of case law and just the lay of the land. Is the District of Colorado granting these, or are you seeing settlements for cases where there's been this expedite request granted and it's only been pending for 2 years? I think that once you've got the facts in the record, you've got the facts in the record. You file when you file. But the underlying facts still need to be evaluated of, is this delay long enough that I'm not going to see an immense pushback, and the judge just saying, hey, 3 months is not enough, expedite request granted or not. I think also you need to be able to allege facts of, hey, this is how long it takes a case where an expedite request has been granted to actually be scheduled for an interview. Like here in Denver, it could be a year, it could be 2 years. It's totally just up to the officer. It's like we've heard, it is voluntary circuit rights at this point. So I might just say, hey, expedite request was granted. Agency has been given the opportunity to schedule this in the last 3 months, and they didn't. So we're filing this now. The agency's already stated that this is a case that's should be prioritized for adjudication for humanitarian reasons or for whatever reason, and they failed to do that. So here's just additional facts that are helpful in filing this, in showing that there's an unreasonable delay.
And maybe time for one final question. Looks like this might be the last one. So how long do you wait between filing a request to expedite and filing for mandamus. Although actually, now that I'm reading that out loud, I think you may have just answered that. Sorry. Yes, that's exactly the same question. So sorry about that. So great. You guys had our audience was thinking along the same lines. Great. So anybody have any final questions for Zach or Simon? Appreciate everybody who did ask them. Two experts, and glad we could use their experience while we have them. All right. Zach and Simon, cannot thank you enough. This was fantastic. And it honestly, the engagement that we had from everybody, I think indicates that the group felt that as well. So we're very grateful for both of you and for your time during what we all know is not exactly quiet period of our practice. So thank you again. And to everybody who joined us, thank you. I forgot to introduce myself at the beginning, but I think most people know me. I'm Kaylee, Director of the Immigration Project at VOLS. And if there are other trainings or other types of workshops like this that you'd like us to see pulled together, please feel free to reach out to me. But thank you, everybody, and hope you have a great rest of the day.
Everybody.